I'm Cierra Bettens. This is APTN News InFocus. On this episode, should the government rewrite the cannabis law in Canada?
Clearly, the Cannabis Act has failed to accommodate First Nations jurisdiction to regulate the health, safety, and well-being of their communities as it relates to cannabis. Further, I would argue that the government has also failed to harmonize the Cannabis Act with the UN DRIP Act of 2021, and in particular with Articles 3 and 4, where it recognizes Indigenous peoples' right to self-determination.
That was former Senator Dan Christmas speaking at the House of Commons Indigenous Affairs Committee at the end of April. The committee is reviewing the Cannabis Act and its effect on Indigenous communities in Canada. And it comes at a time when the Nova Scotia government, along with the RCMP, are coming down hard on a handful of Mi'kmaq communities where unlicensed pot stores are operating. And after an enforcement order was launched in December 2025, there have been more raids and more arrests. So to explain how all of that comes back to the Cannabis Act, I'm joined by APTN reporter Jesse Staniforth in Montreal. Jesse, thanks so much for joining us on InFocus again.
Thank you so much for having me.
So the Cannabis Act came into force in 2018 under former Prime Minister Justin Trudeau. Why does former Senator Dan Christmas say it failed to accommodate First Nations peoples?
Well, it isn't just Dan Christmas that takes that position. I think probably the best place to begin with the Cannabis Act is with the fact that the words First Nations don't appear in it at all. And the word Indigenous appears once. And that was a really big red flag when the act was tabled as a bill in 2018, and it was something a lot of people commented on the time. I had just entered, I was a cannabis journalist at that time, and I had just come from Indigenous journalism, and so of course my first thought was, how is this going to affect First Nations? And I remember looking at the act and thinking, well, that's missing something. One of the loudest voices at the time was the late Murray Sinclair, and just a couple of years out of his time as commissioner of the TRC, he was senator by that point. And in March of 2018, we're looking, 7 months ahead of legalization. He said, no, we need more time because First Nations are included in this. And he was really concerned about the potential effect that this lack of inclusion was going to have on Indigenous communities. And ultimately, he was talked into voting to pass legalization. There were a couple of the health minister and minister of Indigenous Services made some promises to him. But, he was one of the first First Nations leaders to really warn that this legislation was on a collision course with the courts. And simply for, it passed over arguably the most complicated aspect of legalization, which is how on earth do you harmonize legalizing nationally with Indigenous rights and treaty and all that? I mean, it just it dealt with that problem by not dealing with it at all. And I think everybody who saw that in 2018 thought it's only going to be a matter of time before this becomes a huge problem.
Mm-hmm. And so we're seeing how this is playing out in Nova Scotia. And I'm wondering, how is the Act sort of responsible for this?
Well, at present, the Nova Scotia government is raiding unlicensed cannabis retailers on reserve. And the basic way to explain that is they are enforcing the Cannabis Act, because under the Cannabis Act, it is an indictable offense to sell unlicensed cannabis. So that's cannabis that wasn't produced according to Health Canada regulations. And it's also an indictable offense to sell more than 30 grams of licensed cannabis. So if you have 60 grams of cannabis that has tax stamps and it appears in Health Canada regulated packaging, you cannot sell that without a license. And that's the law that the RCMP is currently enforcing when they make these raids on reserve.
So Dan Christmas said that he had a solution to this. What is it?
Well, he had a very simple suggestion, which is also kind of complicated. And his suggestion was to add an amendment to the Cannabis Act saying, quote, the inherent right of self-government, end quote. And he's referring to the inherent right of self-government as it appears in Section 35 of the Constitution. He wants to add in that includes jurisdiction that extends to, quote, those services pertaining to cannabis and authority to administer and enforce laws made under that legislative authority. Now, when he mentioned this, when he proposed this to the Senate Committee on Indigenous Peoples, he said, this should sound familiar to you senators as it's modeled on the Act respecting First Nations, Inuit, and Métis children, youth, Youth and Families, which was Bill C-92. And the Supreme Court upheld that bill in 2024 as recognizing the right to Indigenous self-government over child welfare. And he said, it's really not that far to imagine that we could make this a similar application to Indigenous jurisdiction over cannabis on reserve.
And so how did that go over at the committee?
I got the sense that people were interested, particularly because it proposes a solution. And it's an actual solution to a problem that people have been looking at for years, wondering how bad it could get. And we're getting some answers about how bad it can get, right? The situation in Nova Scotia right now is pretty bad. The province is conducting raids on First Nations. First Nations are closing their borders. They're banishing provincial officials. This is a situation getting pretty bad indeed. And I think a lot of people are looking for the opportunity to turn the temperature down around cannabis on reserve and turn it into a discussion about what can be constructive. And this is not just in Nova Scotia. Anywhere, basically, there's a collision course between Indigenous retailers and provincial or federal authorities. I think there's probably people thinking, there's got to be a better way. And so the sense I got was that people heard Dan Christmas's suggestion and said, okay, this might work. We'll certainly hear it out.
So the committee also heard from others on this, and here, for example, is Sarah Mainville, the former chief of Couchiching First Nation in Ontario and a lawyer at the legal firm JFK Law.
There are solutions, ready-made solutions. One of the solutions would be that our proposal that a Cannabis Act regulation opens a doorway to license the old personal growers regime through the medical cannabis solutions, and have that grown-up gray market offer good examples of safe adult use cannabis supplied to First Nations owned cannabis retail stores.
So what is Sarah Mainville talking about here when she's talking about this gray market?
Right. Okay. Well, I should start with the idea of the black market. And the black market is a term that most people in cannabis stopped using a number of years ago. As I was entering into covering the industry around 2017, 2018, there were a lot of black operators, black people who are operating in the industry, both in the United States and Canada, who said, look, we don't like the association between blackness and criminality. People were saying it's not that there's an etymological reason. This isn't a secretly racist term. They're just saying, look, we would rather not refer to something that is criminal as black, particularly considering, there's this statistical over-policing and over-incarceration of black people under cannabis prohibition, particularly in the United States, but also here in Canada. And that over-policing and over-incarceration in Canada also extends to Indigenous people. So that's, one of the reasons we don't use the term black market. People in the industry will talk about the illicit market or the underground market, or if they happen to be maybe a little bit more friendly to it, they'll talk about the unlicensed market as the legacy market, right? But when we talk about the gray market, this is something else entirely, and it's a term that endures, I think, because it describes the gray area between legal and illegal. Prior to federal legalization, Canada had this enormous gray market because, like Sarah Mainville mentions, there is what she calls a private growers regime. This is a system under which a medical patient could contract a grower to grow their medical cannabis for them and supply them with it. And the growers were licensed by Health Canada. They had to abide by a whole series of circumstances, and then they would produce medical cannabis. Now, what happened is a lot of them produced a lot of medical cannabis and diverted some of what they were producing into the unlicensed retail market. And you ended up with, it used to be going to cities like Toronto and Vancouver, there would be many dispensaries that were not licensed, that were not subject to any oversight, but they were selling cannabis that was produced under legal conditions. And that's basically the definition of a gray market. And that's what she's talking about, returning that idea to reserve so that on reserve people would be bringing in legally produced cannabis.
So Mainville is talking a lot about solutions, and I'm wondering, what are some of her solutions to this?
Well, if I understand her correctly, I don't really want to put words in her mouth, but like I say, she's saying if First Nations are in charge of their own cannabis policy, they don't need provincially licensed retailers. They don't need an authority from outside the territory coming in to say, okay, this shop is licensed or that shop is licensed. Now, under the current law, all of these shops on reserve would be illegal, but What she's suggesting is, well, what if they weren't, right? What if shops on reserve could be authorized by the the local band council? In that case, when she's talking about a gray market, like I mentioned, she's talking about bringing in product that has been produced under Health Canada licenses. And so this is very similar to pre-legalization gray market. From the perspective of the consumer, people who are buying gray market cannabis, it's desirable because they know that they're getting cannabis that was grown under regulated conditions. And so if you're concerned about the presence of something like pesticides or fungus or heavy metals, any kind of contamination, you're not really going to get that because this was produced under rules. So it might not be sold under provincially regulated retail, but it's cannabis that was produced according to those regulations, and then it's being sold under regulations that are particular to the territory. I think that's basically the kind of schema that she's presenting.
So your online story said that Mainville is also working with First Nations to write their own laws. And do you get the sense that those laws will be respected by the federal government and police?
That's a huge question. And what it comes down to is really whether the federal government is willing to work with people like Sarah Mainville and Dan Christmas and accept Indigenous alternatives to the federal and provincial cannabis system for communities on reserve. I think it's probably something the federal and provincial governments are going to have to find a way to work with because, even if we were to imagine a hypothetical Supreme Court decision tomorrow that says, you know what, First Nations have no right to sell cannabis, period, that's the end of the story. It's really hard to imagine cannabis retailers on reserve simply accepting that and giving up. I think there would be a hell of a fight. And the way that would look is probably like a continuation of what's happening right now, in which, provincial and federal police are coming onto reserve. They're arresting Indigenous people and they're trying to raid and arrest them into compliance. But these are communities where we've got economies that really rely on cannabis. And the idea that folks are just going to give that up seems pretty unlikely. So the way forward feels like it's going to have to include some accommodation from the federal and provincial governments. Honestly, one place it just really needs attention is there's no mention of Indigenous people or First Nations in the Cannabis Act itself. And Dan Christmas's suggestion to start there just seems like as good a point as any.
On a related note, where do you think this issue goes from here?
Well, there's a number of possible directions. Three that I have been thinking about. Number one, Parliament takes Dan Christmas's advice and amends the Act. To me, that would be probably the most interesting way forward because nobody really knows what it would look like, right? The second is that the Supreme Court comes to a decision. Maybe the Supreme Court decides in favor of cannabis on reserve, or maybe it decides against. That would open up a bunch of different possibilities in either direction. And I guess the final possibility is the question remains unresolved, and those provinces who want to continue raiding retailers, they do that, and they continue inflaming tensions and turning up the heat on a situation that's already pretty uncomfortable until things become too unpleasant somewhere and something happens, and that forces people to react suddenly. And I think, speaking with people around this, I think everyone would prefer if people reacted slowly rather than trying to solve this problem quickly in reaction to some kind of a crisis. I think overall everyone would hope for the temperature to be turned down. But like I say, these are three possible options. There could be 30 more that I haven't thought of.
So my final question, Jesse, if Parliament does amend the Act the way that Dan Christmas suggests, what do you imagine happening at that point?
I think that would be utterly fascinating, but I also think it would probably be pretty complicated. If we're basing the proposal on the child welfare law, then we can sort of imagine each individual community then goes into the process of coming up with its own cannabis regulatory system. And after they've done that, they're going to need to find the common ground to sign agreements with the federal government and the provinces to make these official. And that's by no means a simple task. And it's also very onerous and potentially very, very expensive. For some communities, Dan Christmas's community of Member 2 being an example, he's been working very closely with the community to develop a regulatory system. Those folks that have been developing and voting on their own cannabis laws will have a head start. And I think some of those communities would be ready to make the jump on cannabis retail right out of the gate they're very nearly ready. And my suspicion is some of those early communities would be the example that other communities would follow. But at the same time, there's a lot of communities that just don't feel like they want to spend time or money on cannabis regulation. They have other issues. We all know all the different issues that you might have on reserve and might want to be focusing your money on. So we could very, very well see communities that say, honestly, we're going to opt out of this whole thing. We can just participate with the provincial or the federal system to make it easier. This is just not that important to us. And then the opposite end would be places like Kahnawake Mohawk Territory, where there has been a push for several years now at Kahnawake where they say, look, we are a dry community. We don't want cannabis here, period. We're going to pass a law, most likely, and say there is no cannabis here at all. And I think we could see all kinds of different regulatory regimes across different First Nations and Indigenous communities. On top of that, in the communities, even the functional communities, we may see disagreements. Right? The communities that are doing really, really well as far as most people are on board, people are developing cannabis regulations and rules for the community and such. Well, they might discover that some of the cannabis operators have been doing really, really well without regulation, and they don't want to be limited by new laws and regulations. So that's a friction that could be created. There could be conflict between cannabis business people and band councils, as we've seen in certain First Nations like Kanesatake Mohawk Territory with unregulated cannabis. All told, amending the act wouldn't guarantee an easy path forward, but it would guarantee a path forward, and a path forward is probably an improvement on the current situation for most parties.
Well, Jesse, always a pleasure to have you on, and thanks so much for sharing your knowledge on this topic. Really appreciate it.
Thank you so much for asking me. I really appreciate it.
Jesse Staniforth is a reporter for APTN News Online, and that's where you'll find his story on changing the cannabis law in Canada. This episode was produced by Mark Blackburn and edited by Jesse Andrushko. Charmaine Straker is executive producer of APTN News InFocus. We want to know if you're enjoying the show. Please leave a rating and review on your favorite player, or give us a follow. It helps other people find the show. I'm Cierra Bettens. Thanks for listening. Talk to you next week.
What is Indian status in Canada, and what can it be used for? We see a lot of comments online about how First Nations people can use their status to get things like tax exemptions, free housing, free education, and more. But what's the truth about status and the reality of these so-called free aspects? I'm Savannah Kelly. Join me and my co-host Jesse Andrushko on APTN News Answers, a new series where we shed light on topics related to current events and issues facing Indigenous people. Watch now on the APTN News YouTube channel.